Good evening and welcome to the Legal Hour with myself, Raheela Hussain, Principal Solicitor of Greenfields Solicitors, showing currently live on Ben TV. Today's programme is an immigration and human rights programme with myself. I'm a solicitor with over 13 years experience in immigration and human rights law, and I would invite our viewers to give me a call if they have an immigration, nationality or human rights question they would like answered. Please give me a call now, live on 0208 808 0693, and I'd be pleased to help any of our viewers with their immigration question. As I mentioned, I am the Principal Solicitor of Greenfields Solicitors. Greenfields Solicitors are a firm of specialist immigration, nationality and human rights solicitors based in North London. We specialise only in immigration and human rights law, and since we established in 2008, both myself and my team have helped hundreds of migrants regulise their legal status and obtain legal leave to remain in the UK. I would like to point out that the information I give on today's show is just that. It's information and guidance. Do not rely on the information I provide as legal advice. If you would like legal advice on your individual case, please do give me a call at Greenfields Solicitors. The details of Greenfields Solicitors are showing on your screen, www.greenfieldsolicitors.com, or do give me a call in the office on 0208 884 1166, and either myself or any of my friendly team will be happy to help you with your immigration problem. So first of all, I'd like to begin this evening's show with discussing some Home Office policies and current immigration rules. As we know, there have been many developments in immigration law and human rights law under the current Conservative government. Today's date is April 21st, 2016, and most recently we saw a Home Office increase in terms of fees which occurred in March 2016. As our viewers know, annually the Home Office do tend to increase their fees, as do the British High Commissions and British Embassies. This year we saw an increase in all immigration applications and British High Commission and Embassy applications. You can find out the current fee of whichever application you intend to make by going either on the Home Office website, where they have published their current fees, or by logging on to www.greenfieldsolicitors.com, where we have frequent updates for our audience and for those members of the public who are interested in immigration law. And you can also follow us on Facebook and Twitter, where we can let you know of the current and updated immigration developments that are occurring and which may affect you or anyone that you are aware of. I'd like to point out something that I see on a day-to-day basis at Greenfields Solicitors when I advise new clients. Often we have migrants who come to our office and they may say to me, "Miss Hussain, I have been recently refused my application by the Home Office. I don't know what my options are. What can I do?" Now at Greenfields Solicitors, we undertake a whole host, A to Z, in immigration law and practice. We deal with things like visas, such as overstayers who require legal status in the UK because they have previously overstayed leave to remain or a visa. We also deal with entry clearance applications. So for example, there may be a husband, a wife, a dependent or a child who wishes to come to the UK to settle. We deal with appeals, which are before the Immigration Tribunal, immigration judges, and also appeals that go further. So they may go to the upper tribunal, they may even go to the Court of Appeal, or they may go to the High Court for judicial review. Now, there is a whole selection of immigration applications and visas, and indeed it's such a large volume and such a large area of law that often people don't know what they're actually applying for, and they don't know the relevant immigration rules. I would always suggest to our viewers, please do get firm legal advice before you make any application to the Home Office. The two reasons are: you do not want to spend a lot of money making a wasted application in Home Office and immigration health surcharge fees. And secondly, you do not want a refusal. Rather, the whole aim of you making the application is to try and sort out your legal status so you may remain lawfully in the UK. Now, when people come to me and they say, "Ms. Hussain, my case has been refused, can you help?" What the Home Office have most recently done, and which I have seen in practice since the end of 2015, is they have given migrants an opportunity where they have refused a case to put something in under Section 120 of the Immigration, Nationality and Asylum Act, which allows people to submit something called a statement of additional grounds. What this effectively means is that the migrant may still write to the Home Office and ask them to consider the case again, but on this account, on this basis, a different version of events which they may not have raised previously. So for example, excuse me, so for example, previously in an application, they may have said, look, I've been in the UK, for example, 9 years, and I have established a life here in the UK and I cannot return to, shall we say, Zambia. And the Home Office may have refused their application. However, when they come to me, in the time that it's taken the Home Office to assess the application, which currently we say is up to 6 months, the migrant may have formed a relationship with somebody, or they may have had a material change of circumstances, like giving birth to a child, or something has happened in Zambia, for example, their family members may have passed, where they say, oh, this has now occurred in my life. I want the Home Office now to consider my application based on these new circumstances. And the good news is, when you submit an application under or grounds under Section 120, there is no Home Office fee payable for the Home Office come back to them with a decision. So do bear in mind, if any of our viewers have been refused a Home Office application and they're wondering what they can do, they have two options usually. The first is to submit a fresh application, which does require Home Office fees and immigration health surcharge fees to be paid, or there is a possibility of submitting a statement of grounds, additional grounds, under Section 120 of the Immigration, Nationality and Asylum Act, and which is therefore not chargeable and therefore is a lot more cost effective. I would also like to touch on a couple of other new measures that the Home Office have introduced. Now, where people have been applying for entry clearance to come to the UK, for example, they apply for a spouse visa, shall we say, in Jamaica, or they're applying for a fiancé visa, shall we say, from Ghana at the British Embassy. If their visa application is allowed by the British Embassy, then they now have up to 30 days from the time the application was granted to enter the UK. They're actually given a visa which is only for 30 days, so they must make arrangements to travel to the UK within that 30-day period. In addition, they have up to 10 days, once in the UK, to attend a local post office in order to collect a BRP, or biometric residence permit, which would have been arranged by them by the relevant British Embassy, and which confirms that they have been granted leave to remain in the UK. There have been many changes and adjustments in the entry clearance procedure in the last year, and it is quite confusing and cumbersome. And we would advise anyone who's looking to make an application for entry clearance, be it as a spouse, a fiancé, as a dependent, any category whatsoever, to come to the UK for settlement, to try and obtain legal advice, because half the documents nowadays are submitted to an address in the Home Office in the UK, and the remaining documents are submitted to the British Embassy. So please do get advice, because the application procedure is expensive and it is complex. Excuse me. I'd also like to touch upon something under the Immigration Act that was introduced with regards to migrants and accommodation. Now, there have been stages since the Immigration Act 2014 was introduced, and the more recent changes that have occurred is where landlords have the right to evict tenants who do not have lawful status. Under the current system, all throughout the UK, landlords may request the immigration status of their prospective tenant in the UK, and if, however, they have found that this person does not have legal status, then they can either deny them accommodation or evict them, potentially through a fast-track process. This issue is being contested by migrants and lawyers, because obviously there is a real problem as to where migrants would go who do not have legal status and who may have family, children, etc., if landlords do not provide them with accommodation, because most migrants are prohibited from claiming public funds to survive on their visas, and particularly this will affect overstayers who do not have lawful status to begin with, or illegal entrants, and they would not be able to necessarily rely on the government to rehouse them in any way. It should be noted that landlords can be fined up to £1,000 if they keep unlawful tenants, it's actually up to a maximum of £3,000 per tenant. So it is important for tenants and landlords to be aware of the new changes. Now, for anyone who has an immigration or human rights question, please do give me a call on 0208 808 0693. I'm live right now on Ben TV, and I believe we have a live caller, David. Hello, good evening, David.
Hi, how you doing?
Hello, hi, how can I help you?
Yes, I have a son who was born here.
Yes.
And he left this country back to Nigeria when he was 7, and he's now 23. And so how is it possible? I don't know his status. Maybe he didn't have his passport then. How can he come back here?
So, did you say he was born in the UK and he left at the age of 7?
Yes.
Okay, so he's been out of the country for maybe 15 years, 16 years now.
Yes, that's
okay.
right.
Are you British yourself, David?
I have leave to remain.
Leave to remain. It's going to be a little bit difficult in this case, David, because unfortunately your son now, according to the immigration rules, is an adult. So he's over the age of 18, which means he cannot come in as your dependent. So he would actually need to qualify in his own right to enter the UK. Now, it depends what his intention is. Obviously, he's entitled to apply for a visit visa. Perhaps he would like to visit you as his father. Visit visas are granted for 6 months. Or perhaps, he may wish to study in the UK, do a master's, a bachelor's or PhD or whatever it is that he's interested in. And in which case, he would apply for a Tier 4 visa. Now, that's called a student visa in simple English. And for your son to apply for a Tier 4 visa, he has to qualify with 40 points under the points-based system in order to successfully be granted a Tier 4 student visa. Now, 30 points is granted where he is actually accepted into an educational institution which is recognised by the Home Office on their Tier 4 sponsored licence list. Now, I would like our viewers to be made aware, I'm sure they are aware, but there are a lot of bogus educational institutions out there who are simply there to take money and not to educate people and then put them in visa difficulties once the Home Office figure out, well, this institution is not right. Therefore, the Home Office for several years now regularly publish a list of Tier 4 sponsors whom they have checked and approved, and we would advise anybody who's looking to study to look at that Tier 4 list on the Home Office website, so that way they don't waste their time, their monies, their efforts.
Okay.
Also, if your son does he have a family here other than yourself?
No, just me.
Okay. Does he wish to study? Is that something he would wish to do or visit?
Yes, obviously she wishes to study.
Okay, and I should mention the other 10 points is based on maintenance. So he has to show that he's got enough money for course study. As you know, the study fees can be quite expensive in the UK depending on what he studies. And also he has to show maintenance, which means he has to have enough money to maintain himself in London or outside. So I have to be quite honest here, he will require several thousands of pounds if he wants to qualify for a Tier 4 visa. All right, David, thank you for your call.
Okay, so right now there's nothing.
So going back to what David mentioned, there are many people who have dependent relatives and they have leave to remain in the UK and they wish to bring over their family members. The immigration rules are quite strict at present. They have been strengthened significantly since Theresa May came into government. And really, the system, as you probably hear yourself on the news on a day-to-day basis, is there is an emphasis for the Home Office to limit the number of migrants to be allowed into the UK. With the EU members being able to have freedom, Theresa May is very keen to reduce the number of non-EU migrants coming to the UK. Now, in practice, we have seen a reduction of migrants coming to the UK or being granted leave to remain significantly because in the last few months, the Home Office have abolished many rights of appeal. What does this mean? So rights of appeal are usually provided by the Home Office where a person has made an application while they still had a valid visa. And if that application has been refused by the Home Office, usually the Home Office would grant them a right of appeal, depending, of course, on the type of application made. And the person could argue their case before an immigration judge, and maybe the immigration judge would overturn the decision and grant the person a visa. Now, in recent months, what we've seen at Greenfields Solicitors is the Home Office have pulled a card, if you like, and they have decided to certify claims. Certification means the Home Office have said not only do we decline your case and refuse you your visa, but in addition, we're going to cancel the right of appeal. So we're not going to even give you a right of appeal for you to try and argue a case before an immigration judge. Obviously, that puts migrant clients in a very, very difficult position. So what are their options? Usually they have one of two. They can seek to lodge a judicial review, action against the Home Office to say this is deeply unfair, I should be allowed a right of appeal, and they can make an application at the High Court and ask a High Court judge to agree with them and allow them an in-country right of appeal depending on the type of application. Or secondly, they can, as I touched on earlier, maybe look into making a Section 120 statement of additional grounds and ask the Home Office to consider new grounds. At all stages, would I suggest that anyone who's looking even to making an extension of a visa application should obtain legal advice, because the Home Office changed the rules, regulations and procedures so frequently that even with all my expertise, it's sometimes difficult to keep up. So if I, as a professional who does this on a day-to-day basis, has to be informed, we would strongly suggest our viewers always get informative legal advice. Now, I believe we have another caller online. Esther, good
Hello.
evening. Good evening. How can I help you?
My brother and his wife recently got married in Nigeria,
Yes.
and they're thinking about moving back to the UK. He's a British citizen, but she's not.
Right, okay.
Is there any way that she would be able to get stay here?
Yes, thank you for your question, Esther. Indeed, she may be able to apply for a spouse visa. Does your brother actually live in the UK?
Yes, he did up until he's just moved back for a year. He moved to Nigeria for a year, but he's moving back to London.
Okay, so he's been there for a year.
Yeah.
Now, what we need to concentrate on here are the spouse visa immigration rules.
Okay.
Now, what's interesting is, great, your brother is a British citizen, but he needs to hit a financial requirement.
Okay.
And the financial requirement set by the government is £18,600, which he must earn as a gross salary.
Okay.
Does he earn that in Nigeria?
He earns about that, yes.
Okay, fantastic. That's really helpful. Now, if it can be shown that he earns more than 18,600 gross in Nigeria, then he can go ahead and submit an application. But because he's actually returning to the UK with his wife,
Okay.
he needs to also have a job offer in the UK, which is also for at least 18,600, and which must begin within 3 months of his return to the UK.
All right. What if his wife also works in Nigeria?
Unfortunately, they don't really look at the applicant, they look at the sponsor.
Okay.
So as long as he can hit the financial requirement and have documents there and has a job offer here, that will certainly help. But please do get legal advice.
All right.
Thank you for your call, Esther.
Very much.
So entry clearance is a very big subject at the moment. It's complicated, there's a lot of paperwork, it can take several hours, for days in fact, for one to prepare an entry clearance application for submission to the British Embassy. So we would strongly recommend anyone who's taken this application, please do not do it until you've got legal advice. As we've learnt just now from our last caller, Esther, perhaps she was not aware, or our audience were not aware, that not only is there a financial requirement, but also there has to be a job offer letter where somebody's returning to the UK. And I believe we have another caller. Hello, Bola, how are you?
I'm all right. Hello.
Hi, how can I help you?
Yeah, please, I came in with my 1-year-old boy. Do you think if I apply for 7 years rule, will I be granted?
How old is your son now?
He's 8 now.
Great, and he came in at the age of 1.
Yeah, but I didn't give birth to him yet.
Say that again, sorry?
He was giving birth in Nigeria.
And he came at the age of 1 and has been here for 7 years?
Yes.
Yes. There's definitely grounds for you to make an application. In fact, in the actual immigration rules, under paragraph 276 ADE of the immigration rules, there is a subsection which states where a child has spent more than 7 years of their life in the UK, then they may make an application for regularisation of legal status and qualify for discretionary leave to remain, which makes them legal. Obviously, Bola, if you yourself are here unlawfully, you would apply yourself to that application and you would say, look, you are the parent and the carer of your child, and you too should be granted discretionary leave to remain. Now, the kind of arguments to make to the Home Office do not just include immigration rules, but also you can say, look, I have established a private and family life. Perhaps you're working, perhaps you have friends or family. Your child is in primary school. So you can argue you have both established a private and family life. And in addition, you can also argue under Section 55 of the Borders, Citizenship and Immigration Act 2009, what's in the best interest of your child? Is it to stay here, or is it for the child to grow up in Nigeria? Probably it's better, in your opinion, for the child to be raised here, as it knows the UK, as it's well informed of British culture, speaks English. Perhaps you yourself, Bola, have nothing in Nigeria, and you would not even be able to provide residency or money to upkeep yourself or your child. So yes, if the question is, do you have grounds? You certainly do, and we would suggest you get strong legal advice. If you wish to call me at Greenfields Solicitors, you can contact me on 0208 884 1166, and I'd be happy to book an appointment to advise.
Okay.
Thank you.
Thank you very much.
You're welcome.
Yep.
Okay, so going back to what we were discussing earlier, let's actually talk. We have another caller. I think we have a gentleman by the name of Elvis. Good evening, Elvis. Hi, Elvis. Can you hear me? Hello?
Hello.
Hi, Elvis. Please go ahead.
Yeah, my name is Elvis.
Yes.
My problem is I got 4-year-old boy
Yeah.
in Ghana, and I just wanted to bring him over here. I just wanted to know whether if I did application in Ghana, are they going to give him a British passport or indefinite?
What's your status, Elvis?
I'm a British.
Yes. I mean, okay, were you British at the time your son was born?
Yeah, he was born before I took my nationality.
Right, okay. Were you legal then? Okay, well, let's just assume you were legal. Yes, Elvis.
I was putting indefinite to remain.
Okay, fine. You could make an application at the British Embassy,
Yeah.
and you can request that the child be registered as a British citizen because you are the British citizen father. So you could go ahead and make an application there. It's much better he obviously gets a British passport out there than rather than him applying to come in as your dependent. That would make no sense. So certainly make the inquiry to the relevant consulate department at the British Embassy in your home country, and it may take several months, in fairness, because it can be quite a slow process out there, but ultimately he should. Going back to discretionary leave to remain, which I think is what Elvis said he had previous to him getting British nationality. What does that actually mean? Well, discretionary leave to remain is a visa that is often granted by the Home Office to people who have got status in the UK outside of the immigration rules. So, for example, they may have been overstayers, illegal entrants, or they didn't qualify under the black and white immigration rules, but rather the Home Office saw fit that their case had exceptional, compassionate or compelling circumstances to grant them something called discretionary leave to remain. Now, the current system is 2.5 years if you're granted leave to remain. You can live, you can work, you can study, you can travel, you can do everything. However, every 2.5 years before that visa expires, you are expected to renew that visa, and it does depend on the route you're on. Commonly, there is a 10-year settlement route, so a person might have to renew that visa every 2.5 years. And after 10 years, they can apply for indefinite leave to remain, but the routes do actually vary. Good evening, Lisa. How can I help you?
Hello, good evening.
Hi.
Yes, I'm calling in regard of my sister.
Of your
Sister.
Okay, sure.
Yeah, she got 2 children.
Yes.
She's a single mother. She got, the first one got British citizen.
The child?
Yeah, the first daughter, it was 10.
Okay, yep.
It was 10 in December. He got...
Registration?
Yes.
Yeah.
So the second child is 9 years.
Okay.
April.
Yep.
This April.
Sure. And is your sister British, or does she have leave to remain?
No, she got 2.5 leave to remain.
She's got discretionary. And did the 9-year-old also apply for discretionary leave?
Yes.
Okay, great. How can I help then?
Yeah, what I'm calling, when the 9 years one, when is it gonna up for British citizen? Is she gonna apply, or what is she gonna do?
Yes, there is a rule under nationality law, as you probably know from the first child, that where a child is born in the UK and hits the age of 10, then the Home Office will grant that child almost automatically British citizenship. So in this circumstance, the child who's 9, do you know when she'll be 10? Okay, April next year.
Yes.
So there's nothing really to worry about, because right now the child and the mother have legal status. As you mentioned, they've got discretionary leave to remain. So it's going to be exactly the same situation as what happened with her first child, which is when the child hits 10, which is going to be in a few